Court is ready to hear argument in 19-497 in Re Academy, a petition for writ of mandamus from Bexar County and the Fourth Court of Appeals District.
May it please the court, Mr. Wainwright will present argument for the relator. Ms. Pettit will present argument for the amicus. Relator has reserved 5 minutes for rebuttal. Mr. Wainwright will open with the first 11 minutes and will present the rebuttal.
Good morning, and may it please the court. A national mandate, the Federal Protection of Lawful Commerce in Arms Act, prohibits the civil actions that plaintiffs brought from being pursued against Academy in this case. Now, of course, our hearts and our prayers continue to go out to the folks involved in the Sutherland Springs shooting. However, sometimes when there's a traumatic event, there's an attempt to place responsibility on those who are not responsible. Academy is not responsible here. The shooter is Devin Kelley and perhaps the federal government. Now, there are two reasons why.
Mr. Wainwright, may I ask you an initial question? And if you want to get to your two reasons, do that first, and then I'll ask you.
Okay, thank you, Justice Guzman. There are two reasons why the PLACA, as the statute is called, prohibits these claims against Academy. First, it is not disputed that Academy is entitled to PLACA protection against these claims unless plaintiffs find an exception expressed and established under the language of the statute here under PLACA. The second reason real parties should not be able to bring these claims is because PLACA says twice in 7903, its opening provision, that civil actions, qualified civil liability actions, may not be brought against state or federal courts. And then in the very next section, it says that any such actions that were brought at the exception of this statute must be dismissed. And that's what we're seeking here. Plaintiffs seek two exceptions.
Okay, Mr. Wainwright, I think I should ask you now, is PLACA a jurisdictional bar, an immunity defense, or an affirmative defense? And is the answer to that question determinative of whether mandamus relief is available? Why or why not?
The answer to your second question is no, it's not determinative of mandamus relief. The answer to the first question is we do not contend that PLACA, the PLACA bar is jurisdictional. In fact, federal courts have said that it's not jurisdictional. This is not like sovereign immunity or governmental immunity. It is a congressional mandate signed into law by the president pursuant to the Commerce Clause and the Second Amendment that provides protection against a certain category of civil actions against licensed retailers and manufacturers. So it's an absolute bar. Now we pled
Mr. Wainwright, would court be obligated to dismiss a case under PLACA even if the defendant didn't argue it was entitled to PLACA's protection, if the court thought that it was?
Justice Busby, that's related to Justice Guzman's question. And the answer is it's not clear entirely whether PLACA has to be pled as an affirmative defense. We did plead it in this case in the trial court and preserved it all the way up. So it may not be an issue the court needs to address. But
well, what I'm trying to figure out is where we draw the line. If we say it's okay to raise this on mandamus, then is it okay to raise a preemption defense or a statute of limitations defense, or do we open up another whole new world of mandamus review here?
Actually, Justice, we do not. This court has on more than one occasion granted mandamus relief to protect federal rights. In the Olshan Foundation case cited in our brief, the court exercised mandamus jurisdiction to reverse the trial court when it refused to abate a proceeding that was governed by the FAA, the Federal Arbitration Act. And there's other cases in our brief that are cited. This is a case that requires this court's attention because we have federal rights created by Congress, and the lower courts have refused to protect and enforce those federal rights. Of course, the Supremacy Clause mandates that federal law governs over state law, and the federal rights will be undermined, and we will not be able to exercise those federal rights if this court does not act. State courts have just as much a responsibility and a duty the U.S. Supreme Court has said, to enforce the protection of federal rights as federal courts do.
But if it's
Does the federal right and protection extend to the negligent entrustment claim?
It does if negligent entrustment is a viable claim. See, PLACA does not create any causes of action. It's very clear about that. So the PLACA exception that you're referring to, one of the two the plaintiffs have argued, negligent entrustment. The other is predicate exception, and I'll come back to that in just a minute. The exception then is dependent upon the viability of a negligent entrustment claim. Here in Texas, like in the state of Missouri, our high court has determined that negligent entrustment does not exist, is not viable where there's been a sale of a good as opposed to lending a good. As former UT law professor Keaton said, and is cited in our brief, when there's the sale of a good, then the possible control over both the good and the borrower is absent because you've sold it. However, when it's lent, there's been a borrowing transaction, then there's the possibility to have some control over it, and negligent entrustment lies in a lending situation, but not in the sale of a good. That's in the FFP versus Duenas case. The Dallas Court of Appeals and the Houston Court of Appeals have also followed suit.
But is that a situation that we should decide on mandamus, whether there is a cause of action for negligent entrustment if the federal statute doesn't apply to that issue?
Well, this court has already said that negligent entrustment does not lie for a borrower transaction. And the Duenas case is from the Texas Supreme Court in 2010. The author is very familiar to me. So that is already the law. The way Congress set up the exceptions, again, there's immunity unless an exception can be established. As a matter of law, there's no fact questions at issue here, and the court can exercise de novo review.
And
The way
Mr.
Congress set up
Wainwright,
this exception,
excuse me, Mr. Wainwright, but getting to that predicate exception, how, and as you know, that conditions of sale must be met in both states under that exception. So how do you get around the illegality of selling a high round magazine of this type in Colorado?
that is actually not a difficult question, Justice Lehrman. If you look at exhibit tab C of our exhibit book, there's a flow chart that kind of tracks exactly how this works. The very short answer is under the Gun Control Act, 18 U.S.C. 922b3, that is where the exception that the plaintiffs are arguing about, the predicate exception is, they claim that there was a violation of federal law. 922b3, the federal law, can implicate the law of other states and say both states' laws have to apply. However, your question was about the magazine. Look at the first two words of 922b3 in Exhibit D. It says, second page of Exhibit D, it applies to any firearm. Congress has defined firearms to exclude magazines. So the plaintiff's argument that a magazine sale in Texas has to comply with the law of both Colorado, the resident of the purchaser, and with the laws of Texas, where the seller existed, the retailer academy, is just wrong.
But isn't it true that
excludes magazines?
Isn't it true that this particular firearm has to have the magazine in order to be to accomplish what it's meant to accomplish?
Practically speaking, you need a magazine for a semi-automatic rifle, but you could load one bullet at a time. So you don't have to have a magazine. But even more to the point here, the Colorado magazine prohibited Colorado residents from purchasing large capacity magazines that hold more than 15 rounds. Mm-hmm. So a 10-round magazine could be on that rifle and it would still operate as intended and comply with Colorado law.
Mr. Wainwright, in this case, wasn't the large capacity magazine packaged with the gun so that, and how does that affect your argument if they're being sold as a package under Colorado law? Could they sell the gun packaged with a large magazine?
Well, it doesn't affect the argument at all because 922b3 again says it applies to any firearm. Kelly bought a separate 30-round magazine, and then he bought the rifle and the 30-round magazine that was in the same box, packaged that way by the manufacturer, not by Academy. Kelly bought the box and the magazine in the state of Texas. Remember, under 922b3, full compliance with the laws of both state only applies if there is a rifle, a firearm. A magazine's not a rifle, it's not a firearm, and that requirement to comply with the laws of both states does not apply to the magazine. Plaintiffs don't argue. They don't admit it, but they don't argue that the rifle failed to comply with the laws of either state. What they're trying to do is, by saying the packaging of an item or even the purchase transaction, what appears on the sales ticket, how many items and which items you buy, or what bag you put it in to take it out, changes the statute. Now, what if someone put a sight in a gun? Does that convert a sight to a firearm? What about a scope? The way that it's packaged is just a creative way by real parties to try to loop 922b3's limitation to application of firearms.
Mr. Wainwright, I think their argument is more analogous to needing a tire on a truck.
I'm sorry, Justice Lehrman, I couldn't hear you.
I think that can you hear me?
I can now.
I think that their argument is more analogous to there needing to be a tire on a truck in order for the truck to be driven.
I see my time's expired. May I answer the question, Chief?
Yes, Mr. Wainwright.
We have to understand to understand the answer to your question, and I'll be succinct, Justice Lehrman, that over the years, Congress has put together a very balanced and very specific regulatory system for firearms. Every firearm defined in the statute to be frame or receiver, muffler or silencer, or weapon is serialized. They must have a specific serial number put on them by the manufacturer, and they are tracked, and you have to qualify through the system to purchase those. The items that are not serialized and are not firearms, like magazines and scopes, are not tracked. So to try to pull the untracked items, not required to be tracked under federal law, into the same category with the firearms, and just attempt to change and rewrite this statute and alter the federal regulatory system that's governed by statutes and regulations.
Any other questions? Thank you, Mr. Wainwright. We'll hear from the state.
Thank you, Mr. Chief Justice, and may it please the court. This is precisely the type of lawsuit that PLACA was designed to prevent. The victims of a terrible crime are seeking some sort of remedy for their loss by suing a sporting goods store based on a novel theory of tort liability and an even more novel interpretation of federal firearms like regulations. Because Congress—
you and relators are calling this an immunity from suit. I wonder, does Congress have the power to strip state courts of jurisdiction over state law claims? And if so, what part of the Constitution authorizes that?
Your Honor, the Congress does not have the power to govern this court's jurisdiction, but it does have the power to grant immunity in the form of prohibiting suit, and that comes from the Supremacy Clause.
So what's the difference between lack of jurisdiction and immunity from suit? We generally treat those together.
They are generally treated very similarly. However, I would analogize this to the context of qualified immunity, which is it has jurisdictional elements, but it's a defense that has to be raised. In response to your previous question of whether a party did not plead, the court would have to nonetheless dismiss it. I think the answer to that question is no. And as a result, but it is an immunity from suit. Congress could not have been more explicit that this type of lawsuit could not have been brought. And so as a result, under cases like McAllen Medical Center and Prudential, mandamus is an appropriate remedy here. And there were a lot
But we've also said in cases like McAllen that mandamus is generally unavailable when a trial court denies summary judgment, no matter how meritorious the motion. And usually when we recognize exceptions to that, it's for things like where the case would have to be tried twice, which isn't really the case here, is it?
Your Honor, the mandamus is a very narrow remedy, and it's usually not available after summary judgment. That is true. But in McAllen and Prudential in particular, this court said that it's a very fact-specific circumstance about whether mandamus is appropriate. And you consider factors such as the need to make sure that courts stay in the proper place within our separation of powers framework, as well as the likelihood that this type of lawsuit is going to recur. The unfortunate reality is that the number of lawsuits that are going to implicate PLACA is increasing, and this court has never had a chance to say what it means. And as a result, under those circumstances, I believe this case meets the narrow definition that Your Honor raised. And it's also particularly appropriate because, as I mentioned, the separation of powers, and I think this goes to Justice Lerman's question about how to read the particular exceptions that have been invoked here. They need to be read narrowly in order to preserve the very carefully balanced structure of cooperative federalism created by Congress, and to permit the state of Texas and its legislature to determine firearms policy in the state of Texas. The plaintiff's claims here would permit Colorado to effectively force Texas to apply, excuse me, its law extraterritorially to a tort committed in Texas. And that is precisely what the PLACA was trying to prevent, which is that it was preserving the ability of a legislature in Texas to determine, based on its own determination of policy, whether such a tort should be able to proceed. The Texas legislature has never recognized or limited magazines in the way that the plaintiffs suggest. Moreover, Congress specifically said firearms in both 922b3 and in the Predicate Act exception, and a magazine simply is not a firearm. For those reasons, we think that mandamus is appropriate here.
Any other questions? Thank you, Ms. Pettit. We'll hear from the real party.
May it please the court, Mr. Vladeck will present argument for the real party in interest.
Mr. Chief Justice, and may it please the court, I'd like to focus my time this morning on three related but distinct arguments. First, as Justice Lerman, I think, pointed out in her question to opposing counsel, our argument that Academy violated the Gun Control Act does not ask this court to hold that a magazine standing alone is a firearm under Section 921A3. Our position is that Academy's predicate offense for purposes of PLACA was selling the Ruger Model 8500 to Mr. Kelly after he presented as a resident of Colorado, a state in which that gun isn't and cannot be sold. Second, this analysis of the federal statute is exactly what the Department of Justice has adopted in the Holcomb litigation, and for good reason. What's more, we know from the record in that case that at least one other Texas retailer refused to sell Kelly the exact same weapon only after he presented his Colorado ID. Like everyone else in this case, except Academy and its amici, it understood that the Model 8500 couldn't be sold to a Coloradan. And third, and most importantly, picking up on Justice Busby's questions, this court need not reach whether PLACA applies in the first place, because at most, it creates a defense to liability rather than a right not to be sued. Thus, even if the district court erred, and we don't believe it did, any such error has an adequate remedy, as this court has recognized time and again, if necessary, on an appeal after final judgment. And I'd actually like to start with this last point, and if I might take my own shot at Justice Busby's question. We believe the best understanding of PLACA is that with regard to new claims, it creates an affirmative federal defense, and that the must be dismissed language was actually relating to existing claims at the time of the statute. In other words, Justice Busby, that it was jurisdictional as applied to pending cases, but substantive defense as applied to new cases. We believe that point is reinforced by the dozens of cases in both state and federal courts where PLACA has been invoked, successfully or not, as a defense, none of which, not a single one, treated PLACA as creating a right not to be sued.
Mr. Vladeck, do you agree that our mandamus precedent and the interlocutory appeal statutes reflect a general policy that resources should not be wasted when there's a gateway bar to litigating? And so if this is if PLACA is more of a gateway bar, why wouldn't mandamus relief be appropriate in this context?
So to respond to this, Justice Guzman, First, the legislature has provided parties with a mechanism for litigating so-called gateway bars. It's the Rule 91A1 motion. I think it's revealing that in this case, Academy did not file such a motion. But more generally, to your Honor's point about this court's jurisprudence, the question that I did not hear Mr. Wainwright answer is what separates Academy's claim in this case from any number of other pure questions of law that defendants assert at the summary judgment stage. How would a ruling in favor of mandamus here not open the floodgates to every single defendant upon having a motion for summary judgment denied? Justice Guzman, on a question of first impression, on a question of significance to the state, whatever those mean, it would seem to just create so much chaos as compared to simply letting this case proceed the way it was supposed to, allowing the claims that are available to go to trial, and if Academy loses at trial, which is by no means a given, allow them a full and complete remedy on an appeal after final judgment.
Let me ask you this. What do the words "may not be brought" mean if they can only be enforced after a case has been brought and finally determined? And if the issue is not determined as a threshold matter, isn't the benefit of the statute lost entirely? And that sort of goes to the harm that I think you were alluding to in your prior answer.
So Justice Guzman, if I might take that in two parts, to the specific question of what does the "may not be brought" language mean, as we point out in our brief, that I think is where Justice Busby was going. That language in federal courts is usually understood to have jurisdictional implications. That is to say, perhaps Academy could have argued in a 91A1 motion that the trial court lacked subject matter jurisdiction. Of course, as you know, not all subject matter jurisdiction denials are appealable immediately. But second, and more fundamentally, if I might refer your honors to tab D of our oral argument bench book, your honors will find there 15 different examples of federal statutes that expressly create a right not to be tried. And the language they use is that parties under the defined circumstances shall be immune. And the requirement that Congress speak expressly serves multiple purposes in this context. One, it protects against Congress accidentally getting rid of claims it might not have intended to. And two, in the specific context of federalism, which you heard about from my colleagues on the other side, it actually protects state law claims unless Congress has been clear in its intent to displace them categorically. And so we actually think that the burden is on Academy to demonstrate that PLACA unambiguously creates a right not to be sued. In fact, Justice Guzman, the language does the opposite. So if your honors might refer to tab C of our oral argument bench book, we quote multiple provisions from PLACA therein. For example, section 7901A5 refers to how businesses in the United States should not be liable. That's not immunity language, that's liability language. 7901A6 describes as one of the concerns animating the statute the possibility of, quote, imposing liability. And then in the very first purpose, when Congress is explaining exactly what the goal of the statute is, in 15 USC section 7901B1, it says the purpose is to prohibit causes of action. Congress has the power to do that in appropriate cases, but prohibiting causes of action is the classic example of Congress creating a substantive federal defense, not a categorical right not to be sued.
Is there any difference in your view between a statute that says suit may not be brought and a statute that says the defendant may not be liable or the plaintiff may not recover?
Justice Blacklock, I do believe there's a difference, and I believe the difference, again, going back to Justice Busby's question, is between whether the proper litigation of that issue would be in terms of subject matter jurisdiction or failure to state a claim. Right, that the may not be brought language, I do believe has jurisdictional implications, whereas may not be liable is a classic failure to state a claim argument. So it would matter at least with regard to what kind of plea would be a basis for dismissal in the trial court. It might matter with regard to whether the defendant could waive it by failing to raise it at the appropriate time. We don't think it makes any difference here, Your Honors, because we haven't argued that Academy waived this argument. Our position is simply that Academy has an adequate remedy, even if the trial court was wrong on an appeal after final judgment. And of course, we don't believe the trial court was wrong in the first place.
On that point, go ahead, Justice Boyd.
Thank you. So setting aside the waiver issue that you just mentioned, your analysis, I think, would reach the same result, or you would take the same position if it was a summary judgment motion based on statute of limitations. Statute of limitations prevents a claim from being brought. And yet a lot of the sort of jurisdictional and federal law implications that are part of your analysis don't apply. So it sounds to me like your analysis is really a whole lot more simple than you're making it.
I'm happy to hear that, Your Honor. I'd be happy to endorse that it's simple. We think it's simple. I just want to make clear to the court as best I can that the multiple different avenues Academy takes to try to suggest that PLACA creates a right not to be sued all end up in the same place, Justice Boyd, which is that they're all lacking for the relevant evidence. They're all lacking for the necessary textual indication that Congress intended such a result. They're all lacking for any case law that has actually treated PLACA that way. And given that the statute has been on the books for 15 years, given that it's been used to dismiss hundreds and hundreds of cases, one would think it would have come up by now. And if I may, even the state in its amicus brief points to the Beretta and Aledo cases as reflecting federal courts treating PLACA as an immunity, but the state itself notes that in both of those cases, the issue reached the Court of Appeals on a permissive interlocutory appeal, not on any appeal based upon a right not to be sued. And so
you suggested that this might be construed as jurisdictional in federal court, but doesn't Reed suggest the opposite by holding that language stating no civil action shall be instituted is not jurisdictional?
Indeed, it does, Justice Busby, and I apologize for defaulting to the federal court answer. But the other case, Justice Busby, that I would point this court's attention to, and this is in response to the argument you heard from Ms. Petit for the state, is the Supreme Court has actually specifically, the US Supreme Court has specifically rejected the argument that just because an immunity claim is appealable in federal court, it is therefore also appealable in state court. And I refer your honors to Johnson versus Fenkel. It's a case that unfortunately we did not cite in our brief, but it's reported at 520 US 911. And in Johnson versus Fenkel, the US Supreme Court held that just because a qualified immunity defense is appealable under the so-called collateral order doctrine in federal court does not automatically mean it is appealable in Idaho state courts, that was a question of Idaho procedural law to be decided in the first instance and indeed conclusively by the Idaho Supreme Court. And so we also think that is fatal to Academy's reliance on Felder versus Casey. In Johnson, the court expressly distinguishes Felder versus Casey and explains that even though Felder required state courts to honor the notice of claim requirement in Section 1983, it would be a rather odd result if Congress could restructure the appellate jurisdiction of state courts, let alone, your honors, if Congress could do so implicitly.
You mentioned permissive interlocutory appeal, and I certainly recognize the strategic value of getting a ruling in your client's favor that's going to require an expensive trial process in terms of maybe settlement. But setting aside the strategy to force a settlement, wouldn't your client want to agree to a permissive interlocutory appeal too? Because your clients and lawyers don't want to waste their time and money any more than the defendant does. And it just seems to me that this would be a pretty ripe issue for permissive interlocutory appeal under the language of that statute.
So I have 2 points in response, if I may, Justice Boyd. The first is just as a matter of procedure. The legislature, in its wisdom, gave that discretion to the district court in the first instance. And so it's entirely possible that Your Honor might have certified a permissive interlocutory appeal in this case. That's not the relevant question, of course, as to whether the district court erred by failing to do so. But to the broader point, I mean, Your Honor, I might just point to the timeline here, which is that we were proceeding fairly expeditiously toward trial. And it was actually Academy's petition for writ of mandamus, first in the Court of Appeals and then in this court, that has really slowed down these proceedings. The motion to strike filed by Academy last night, part of the dispute there is because the deposition testimony in the Holcomb case hadn't had a chance to come into this case because Academy pretermitted that very process. So, Justice Boyd, I guess as a matter of both law and practicalities, it's not obvious to me that the trial court had any obligation to grant a permissive appeal, and I don't actually think it would have speeded up the litigation, sped up, pardon me, especially if we are correct, as I think we are, on the predicate exception, where that issue would have just gone straight to trial, and where if Academy lost on the merits, which of course is by no means a given, it would have had every opportunity to appeal de novo without having to meet any of the higher standard in a case that would not raise any of the risks to Texas courts that opening the floodgates of mandamus would bring with it.
Taking a look at that predicate exception, so a Colorado citizen that owns a farm or a ranch in Texas, can that citizen legally possess a large capacity magazine at his farm and ranch while staying at his farm and ranch in Texas?
He may, Justice Bland, and that's because, like most states, Colorado law does not apply extraterritorially. And indeed, I think this is where there might be some confusion in the briefs on the other side about what exactly our argument is. We are not trying to suggest that Colorado law somehow applied extraterritorially to the sale of the Model 8500 here in Texas. The question is what Congress provided in the Federal Gun Control Act. And the Federal Gun Control Act of 1968 was actually motivated, Justice Bland, by the exact concern, not of the farmer who's a dual resident, but of the person who lives near a border of a state with more restrictive gun laws, who just pops across the border into a friendlier jurisdiction to buy more guns. The statute was initially known as the State Firearms Control Assistance Act. And so whereas Academy portrays the question as whether Colorado law barred the transaction in Texas, of course, that's not what Congress was trying to do. The Gun Control Act, Justice Bland, would not prevent the farmer in your hypothetical from lawfully possessing a large capacity magazine in Texas because he or she did not buy that, right? Presumably he or she did not buy that from a seller who was bound by the Federal Gun Control Act. And if I may, I think this is where I think the merits argument for Academy runs into the most trouble. Your Honors heard Academy and the state both try to portray our position as whether the magazine can be treated as a firearm. With Your Honors' indulgence, I'd actually like to put up the text of section 921A3. So Academy pointed, Your Honors, to 922B3, but of course the definition of firearm is in the preceding section. And what I'd like to focus Your Honors on, and this by the way is tab B of our bench book, the term firearm, according to Congress, means, and note the distinction between subsection A and subsection B. Subsection B says the frame or receiver of any such weapon, but subsection A is broader. So deliberately, subsection A encompasses the entire weapon, the box. And as we suggest in our briefs, this is reflected in not just how the Justice Department took this position, not just how Academy put out a map showing which states can and cannot have long guns sold to. But Your Honors, it's also reflected in the very fact that Ruger manufactures and sells and markets an entirely different model, the Model 8511, that is called the state compliant model. And as Academy's own compliance officer testified in deposition testimony, the Ruger specifications specifically say that the state compliant model is for those jurisdictions that are otherwise restricted, including Colorado. And so it seems like everyone in this case understands that the Federal Gun Control Act bars the sale of the Model 8500 to a Colorado resident in any state, including Texas, except Academy and its amendment.
What are the differences, counsel, between those two models?
So Justice Blacklock, the only difference between the Model 8500 and the Model 8511 is the capacity. Now, I should say, forgive me, there's a weight difference that corresponds to the capacity difference, but that's it. The only difference, and if Your Honors, I know that there is a motion to strike the exhibit in tab A, but if Your Honors refer to the exhibit in tab A, Justice Blacklock, you'll see they have the exact same specifications, jot for jot, except for their capacity. And so we think that that underscores our position, which is that the Model 8500 is the weapon.
Doesn't capacity mean magazine?
So Justice Devine, the way it's marketed, and I did not write the marketing material, the way it's marketed as capacity. And indeed it is sold as a quote, high capacity, auto loading, semi-automatic rifle. Now, two of those things can be accomplished with a smaller magazine, but not the third, not the high capacity. And again, this was not a fluke. This was how the gun was marketed by Ruger. It was how it was advertised by Academy. Your honors will find Academy's website advertisement at tab E of our bench book. And insofar as it is properly before this court.
But to make it clear, both guns will shoot a 30-round magazine as well as a 10-round magazine.
That's true, Justice Devine, but I think the point is the statute Congress enacted asks not about the function of the weapon, it asks about the sale. Could this gun have been sold? And if we were to go up on the street and ask 10 people, is the Model 8500 AR-556 a weapon, as Congress has defined it in Section 921A3, I have to think all 10 would say yes. Indeed, Academy tries over and over again in its briefs to suggest that it sold 3 things to Mr. Kelly. By its own reasoning, it sold at least 6, because it also sold the trigger lock, it also sold the flash suppressor, it also sold the collapsible stock. In fact, the Model 8500 had all of these things in addition to the frame or receiver. And Congress's unambiguous, express textual choice in the language of the Gun Control Act was to treat the weapon as more than just the frame or receiver. Our view is that that has to mean when the gun is packaged and sold, advertised, displayed, all for the same purpose, that one package that is sold under one SKU that cannot even be opened by Academy is the weapon.
But isn't it true that the only component of that package that is serialized is the receiver? And both of those are exactly the same in the 8511 and the 8500. Is that true?
That's true, Justice Devine. I would just note that the flash suppressor, which is also regulated differently in different states, is not serialized. The individual bullets, even though states like Texas have regulations on what kind of bullets can be used, are not serialized. So we think that's true as a factual matter. We just don't think it affects the analysis of whether the Model 8500 AR-556 was a weapon within the meaning of 921A3. That's why we believe the predicate exception applies, and this court, even if it reaches the merits, doesn't have to reach the negligent entrustment claim. And it's why we believe Academy was the only party that didn't understand this basic fact. And if there are no further questions, I thank the court for its time.
Any other questions? Thank you, Mr. Vladeck. Mr. Wainwright, I believe you have 5 minutes. 4 minutes. 5 minutes. Go ahead.
Yes, that's my understanding, Chief, that there's 5 minutes remaining.
Oh.
Thank you. I have 3 points to respond to. One, the trial court erred in its ruling on the motion for summary judgment here. You'll notice opposing counsel did not mention a single fact question. Neither does their brief in this court. So it should be ruled on as a matter of law. We don't have to file a 91A claim. There's no such requirement. And we did attempt a permissive interlocutory. I'm sorry, Justice Guzman.
Could there be a fact question about what exactly was sold? 6 things?
Not at all, Your Honor. And that takes us right to the questions that Justices Blacklock and Devine raised, and where my opposing counsel talked about a Model 8500 versus a Model 8511. What was absent from his discussion was those numbers refer to the box that contains items. It does not contain, as Justice Devine pointed out, any identification of the weapon or the magazine. An 8500 box, again, put together and the items put in it by the manufacturer, has the AR-556 rifle with the 30-round magazine. The Model 8511 box has the exact same rifle with a 10-round magazine. But if you look at what the Bureau of Alcohol, Tobacco, and Firearms tracks and what the federal government requires to be serialized and tracked, the ATF Form 4473 that has to be filled out to purchase a firearm tracks the AR-556, the actual firearm. So it's a little bit of sleight of hand to say that we're talking about 2 different models. The models
when you refer to
the boxes.
When you refer to the firearm, you're referring to the serialized receiver, are you not?
The firearms defined in the Gun Control Act to be a receiver or a frame, and it is not correct. I need to make a correction that the receiver is the weapon. It is part of the weapon. In addition, there's a barrel, there's a bore, there's a sight. The magazine fits up in it. The receiver is the skeleton, if you will. It is not the firearm. It is serialized. Silencers or mufflers are serialized, and the weapons are serialized so they can be tracked. Magazines are not serialized because they're not tracked. The Congress made a policy decision years ago, and has refined that some items are important enough and concerning enough to be serialized and tracked, and made a decision that other items are not to be serialized and tracked. In fact, in 2004, the Congress decided that magazines shall not be serialized. There was a period of time, the statute cited in our brief, when magazines needed to be serialized. That statute expired in 2004 and has never been reenacted. Let me also mention, with regard to the McAllen and the Prudential cases and the adequate remedy by appeal, as this court understands, it has discretion to decide issues that are important enough to be addressed on mandamus. In McAllen, the court held that violation of a statute with regard to medical liability cases where an expert report is required entails the balancing of the pros and cons by the legislature such that the court should enforce by mandamus a dismissal of a case in the context of an expert report. This is, I believe, before there was an interlocutory appeal for such matters. And in McAllen, the court said there is, in most of the instances where we've exercised mandamus, it is where there is a right that can never be recovered or exercised if we don't do it. If we agree with real parties here in the outcome here, then we will never get relief unless we go to trial.
Mr. Wainwright, so how do you distinguish statute of limitations defenses, the denial of a motion for summary judgment based on statute of limitations?
The court has discretion to decide things under Prudential, balancing these considerations.
Right, but you said that the main consideration is if it's a right that by statute simply cannot be pursued in court. Isn't that the same thing as statute of limitations?
Yep. Justice, the most direct answer to your question is to, again, correct something that you heard previously. The Second Federal Court of Appeals, New York City versus Beretta case, said that by its term, PLACA bars plaintiffs from courts for the adjudication of qualified civil liability actions. It curtails, another quote, a co-category of causes of action, and it, quote, immunizes a specific type of defendant from a specific type of suit. That language means the suit should not be brought, as the statute says, as opposed to limitations where you may get into discovery and knowledge, and it may be well down the road past discovery before you even get to a ruling on limitations. It's not jurisdictional, but it is a bar to bringing these cases.
Any other questions? Thank you, Mr. Wainwright. The case is submitted and the clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.